The next case to come before the court is in re JMAM and AC. Is all counsel present?
Yes, Your Honor.
Okay. You will both share 15 minutes to present your arguments. You can divide that up accordingly. And the arguments are being recorded, so please stay behind the podium and keep your voices up. And you should not use the names of children or minors or victims during your argument. You may use initials or generic terms like the child. The judges have read your brief and all the briefs in this case and are ready to proceed when you are.
May it please the court, Your Honors. My name is Jason Mercer and I represent Appellate Mother. And I'm going to shoot for about 8 minutes and then Attorney Medvick take it from there. So if you could just give me about at 8 minutes, let me know if I'm going past that and I'll wrap it up. So Mother has 2 issues before the court today. Issue 1 regarding the conditions noted in RC 215104B and C to find children dependent. And issue 2 regarding certain rights granted to citizens and parents, including the right to raise children free from government interference. And that word interference, I think, is key, and various privacy rights. So Mother can consent to waiving these rights and can revoke consent at any time. So first I want to shoot through 4, hopefully quick, opening discussions, and then I'll come back into the main argument. But first, there's 3 cases that influence both issues. First one is Stanley v. Illinois, held that the state cannot, consistently with due process requirements, merely presume a parent is unsuitable. It must be established on the basis of individualized proof. The second one is Washington v. Glucksberg, held that the 14th Amendment's due process clause has a substantive component that provides heightened protection against government interference, there's that word, with certain fundamental rights and liberty interests, including parents' fundamental right to make decisions concerning the care, custody, and control of their children. And then the last case, which I understand is not controlling, hopefully it's persuasive. It's the Second Circuit held in Duchenne v. Sugarman, and you'll see that the wording in here sort of ties in. The right of the family to remain together without the coercive interference of the awesome power of the state encompasses the reciprocal rights of both parents and children. And then the court went on to explain that children have the constitutional right to avoid dislocation from the emotional attachments that derive from the intimacy of daily association with the parent. And it's that dislocation which is happening now and has been happening for some time. So, point 2 of the quick points, these will be quicker. So, both RC 215104B and C focus on conditions. Conditions of the parent and conditions of the environment. There are no conditions or environments such as to warrant the state in the interest of the children and assuming the child's guardianship in this case. Third, CFB makes the point during their argument regarding the constitutional issue that this is temporary custody and not permanent custody, but the issue isn't really permanency, it's interference, and interference is interference. Fourth, Mother had not violated any court order by the time of the trial, and I think that's just something to keep in mind as we go through this. So those 4 things being said, I'll start at the beginning, the genesis of the issue. So per CSB caseworker in testimony, Mother first stated she left her children with a 14-year-old babysitter, and then later indicated in a different conversation that her friend was going to drop her off and then go back to the children. So there's no retraction noted anywhere. It's sort of like she said one thing in one conversation, another thing in another. CSB's own brief says there's an inference that the children were left alone. And I think that word is important. It quotes an inference on page 4 of CSB's brief. There's no evidence, let alone proof, that the children actually were left alone. So worst case scenario, even if they were left alone, they were 10 and 7 at the time, and we know there's no statute in Ohio that governs that. Doesn't make it absolutely okay that a 10 and 7-year-old were left alone, I understand that, but I'm picturing, what if the children were outside riding bikes, alone, or with each other, and mom was inside the house? Does that make it okay? It's just one of those situational things. CSB's brief, page 4, says Mother was seen at the Northfield Casino, in quotes, which is across the street from her home. So, she's across the street from her house. We don't even really know. Do you have a question, Judge? Okay. We don't even really as far as I can see, know exactly how long. It's not clear in the record exactly how long this happened. Speaking of CSB, let's consider their initial complaint. And CSB states, and I quote, "They filed an amended complaint to add allegations that mother had, since the original complaint's filing, stated she would not cooperate with the agency, would not work on any case plan objectives, it would not undergo drug testing." Well, I think she's pretty clear there. She's revoking her waiver of those rights. She's allowed to do that. None of these things that I've just mentioned, the things that they say mother's not going to do anymore, have anything to do with RC 215104B or C, which again focus on conditions, not whether or not mom is doing certain things for CSB. So the original complaint, I really think, had zero merit. I mean, if you read through that complaint, there's nothing in there. So they filed another one just a short time later with stuff that happened after the original complaint was filed. This complaint I also think lacked merit because it's just stuff that they kind of prompted. So why wouldn't mother cooperate? There's 25 things that mother had to do to get her children back. And remember, this all started because there was an allegation. It's not even clear in the record whether they actually were found alone, but there's an allegation that the 10 and 7-year-old were found alone, or were alone. And because of that, they took the child, or the children from mother, and said, if you do these 25 things, we'll give them back to you. And I won't go through all 25, they're listed in mother's brief, page 20 to 21, but they included, some of these are par for the course, but diagnostic testing, psychiatric evaluation, intensive outpatient treatment, inpatient treatment, and the craziest one, therapeutic medication. So in my head, I'm thinking, the awesome power of the government is trying to compel mother to take medication in order to get her children back. And I think that's way overboard, considering the circumstances surrounding it. So looking to CSB's brief, obviously it's going to contain the worst of mother's behavior. And by that I mean, just her back and forth with her own mother, some of the things she was saying to her kids. And none of it seems to rise to the level of a government being required to take custody of her children. And some of it to me reads like a Facebook post. You've all seen those goofy social media posts where someone gets on there and you're like, you probably should take this family argument elsewhere. But a lot of it is just the kind of thing you would see on social media, and those people all still have their children. Not saying you should air your dirty laundry, but it just seems like that kind of thing. So a lot of their strongest arguments relate to a prior case in allegations. So again, there's nothing related to 215104B or C.
Counsel, you are ready.
Thank you, Your Honor. And their biggest concerns arise after the children were taken, and again, those concerns don't relate either to 215104B or C. One last thing. There is a big allegation in CSB's brief that there were men, in quotes, seen in the backyard of the home in the small hours of the morning smoking something that did not smell like tobacco or marijuana. There's no consideration by CSB that father was involved with his family roofing business and prep work may be done from that site, and we know all that roofing stuff smells weird. Who knows, but there's just no consideration even given to that. There's testimony about it on transcript 1, page 101. And just worst case scenario again, assuming there was something going on out there, the men were in the backyard in the small hours of the morning. So how is that impacting the children's environment? They're outside, the small hours of the morning, whatever that means. It doesn't go to the children's environment. And again, it doesn't go to those two statutes. So mother respectfully asks this court to return her children to her custody, or in the alternative, to return her children to her custody with a reasonable frame of protected supervision. I think it was that 25 things that just really, at first she was like, yeah, we can do this, but when she saw that list, she's like, this is just too much. So one of those two things is what mother requests, and I rest. Thank you, Your Honors. Any questions?
No, thank you.
Thank you.
Good morning, and may it please the court, I'm Alan Medvick. I'm here representing the appellant father in this matter, and I will try not to rehash what Mr. Mercer has said very succinctly well. I would point out again, this is principally, and I am here principally arguing on the father's behalf regarding the adjudication of these children, and that there was insufficient evidence presented to demonstrate that these children were dependent under subsections B or C. There's no indication, as has been indicated, there's no indication of any time in which these children were unhoused, or they were not fed, or they were not taken care of. There is innuendo and opinion and concern without supporting evidence that there may have been a day where the mother left the children at home alone. I think first I would point out that at trial, counsel objected to the caseworker's conversation regarding that claim, and the magistrate stated in the record she was considering only it as background for the issuance of the complaint, and yet somehow in the opinion from the trial judge, that reference ends up incorporated, and the fact that somehow there were different versions, which are, as indicated, not incompatible, that a 14-year-old or the client's or the mother's friend had returned to watch the children, that those rise to the level of a concern, despite the lack of any admissible evidence regarding that claim. I would indicate there's also no admissible evidence presented regarding any history of domestic violence. Over numerous objections, the trial magistrate, I think ultimately there is no evidence of a history of domestic violence entered into the record. There are claims of prior DV charges for father and mother, none of which are presented with certified documents, and all of those claims were objected to by trial counsel. And there is no claim that, or evidence presented that these children were ever, regardless of the condition of the parents, there's nothing to indicate that these children were at risk of harm, that to demonstrate what detriment they were facing that would justify the agency's involvement in these cases. There is no evidence of a mental health concern under subsection B. There's no evidence under any consideration that they were ever homeless. There was a pending eviction of mother from the home when father and she were in the process of separating. They reconciled before the end of this case. But mother was not evicted. There's no evidence that she did not have someplace else to go if she had been. There's nothing to indicate that these children were ever at risk of having their basic needs not met. There's nothing to justify the agency's involvement here. The father was not visiting. Grandmother had the children under a safety plan already, as has been indicated by Mr. Mercer. There was no obligation to provide drug screens, to do any of these actions prior to adjudication, to cooperate with the agency. It's not again, and I've said this to this court before, it is the agency's job to find these children dependent. It is not the parents' job to prove that they are not. And very often, these cases are reversing that burden and placing the burden on the parents to establish that they have not done anything wrong. When it is very clearly the law that by the rules of evidence, the agency has to prove by clear and convincing evidence that these children are dependent under B or C. And they did not. Even under the broad definition contained in subsection C of the dependency statute, there is nothing to show that the agency could be justified in coming into this court. Even in the case of pending domestic violence, as an isolated incident, this court has established in the past that there must be some indication that that domestic violence or drug use must have some impact upon the children. That has to be there, and it has to be demonstrated by the agency. And in this case, there is an absolute absence of any of those considerations. I will indicate that a pattern of domestic violence, this court, I will agree, has found that that can be used to impute concerns of impact on the children. but they've failed to establish that historical pattern in this case as well. So I do not see anything in this record, and I think when you review the transcripts and the evidence presented, you will find that there is not. Do you have a question? I think you will find that there is an absence of evidence, and I am specifically asking that the agency do their jobs in these cases. They are not presenting evidence sufficient to sustain these cases. They are having a caseworker come in as the sole test witness to testify to these facts, and that is insufficient to establish, and again, speaking to, as Mr. Mercer did, to the claim that because this is merely a temporary custody and an initial order, that somehow that burden is lessened to every one of these cases is potentially a permanent custody case. And to open these cases on hearsay and innuendo is improper, and it is happening in, not just in this case, but in others, but in this case specifically, there is no evidence to present that the agency presented to show that these children are dependent. And so with that, I would ask that you reverse this decision and have the trial court dismiss the claim of the agency. Thank you very much.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will